I have a couple of very quick questions to acquaint our audience with your backgrounds. And first, I'd like to ask Justice McKinnon, where did you study law and what year were you called to the bar?
I studied at University of Ottawa Law School with the very, very famous Dean Feeney.
Oh, yes.
Started there in 1966. We had 69 students. You remember he'd come into the class, Ernie, he'd say, look at the person on your right, look at the person on your left.
Exactly.
You graduate. Well, we were 69 when we began, including one woman, Wendy Miller. And when we graduated, there were 22 of us. And Wendy dropped out, I think, at Christmas because the only woman among 69 people. Just amazing how different it is. When I go and guest lecture now at the law school, it's the men who are in a minority. And in any event, I graduated from Ottawa U in 68, did my articles with Binks and Chilcott, and then did the bar admission and graduated in May 1970. In those days, you had to go to Toronto to do the bar ed. You had to, pick up stakes, find an apartment, etc. I was married. It was very, very difficult, which led to a crusade to get a home bar admission course here in Ottawa, which we eventually did.
Correct. I could pick up on what Justice McKinnon said, because I remember when I joined the law school in 1972, he did exactly what he said. He lined about 10 of us up and said, look beside you, 40% of you will not be here to graduate. And he gave us all an article, any good law school flunks 40% of its students. That's how we started.
Yeah. It was difficult because I remember the Christmas exams first year, we all had to line up and go in one by one to see Dean Feeney. And a few people fainted waiting in line. They were so nervous and apprehensive. I remember I think I had 59% or something, some horrible mark. He said, I don't think you're fit for law school, Mr. McKinnon. I just don't think you're going to.
He was actually, in his own way, he was trying to get us, but he told us, I don't know if you heard it from him. He said, it's a tough profession out there, so I'm going to be tough with you.
Yeah, no, he was very tough. And, but he also had a lovely, generous side to him.
Yes.
I have a couple of friends whom Dean Feeney actually paid their fees.
Wow.
Yeah.
And he wrote a leading book on wills and estates.
Oh, he was I think, the Canadian expert on wills. And then Professor Jim McKenzie took over the writing of that book from him.
Well, 1974, when our class graduated from law school, actually, we had a virtual Zoom meeting last Friday, because I'm always honored to facilitate our class reunions. We're 45 years to the day on Friday for our call to the bar. But as his honor will remember, the first city of 5 they chose to do a bar admission course outside of Toronto was Ottawa. It was 1974. And by then I'd gone to kindergarten, elementary school, middle school, high school, BA. I think I'm one of the few people in Ottawa that actually went to the bar admission course. So I went to Algonquin College. You remember Algonquin College? I think you were part of getting that together. And I went in to sign up for the bar course. And the guy said, okay, that's $75. It's 6 weeks. I said, no, it's $750, 6 months. Oh, he said, I thought you were signing up for the bartender's course. So maybe I should have.
Yeah, I'd forgotten we were at Algonquin. I was there. I was I was teaching criminal law there at the bar when it was first.
Yeah. It was great that we did that here. We broke the ice like we did many things. There was part of the interview today with his honor is the great article he wrote on the merger of the courts and the leadership the Canadian Common Law Association has taken in its history and still does.
Yeah.
But Toronto doesn't read about it as much, but.
Thank you both. We're still having some technical difficulties with the sound, but we'll continue. And we'll make sure everyone gets a replay. So now we're looking at 3 perspectives on improving access to justice. We've broken up the interview in 3 segments, and that is the telescope, the binocular, and the microscope. I look forward to these groundbreaking, which I know they will be, conversations. The telescope conversation focuses on institutional aspects of our legal and court systems, the rules, and the processes.
Yes.
So I'll begin with, Your Honor, people who are trying to reduce the human, economic, and systemic costs of conflict wonder why you retired from the bench. In a general way, what are your evolving views on dispute resolution options, and where are we today?
Okay, well, I chose to retire from the bench 1 year early, and it was just a very, very personal thing that I didn't want to have to retire. In other words, I didn't want the guillotine to come down. So I went a year early. I had been approached by the folks at Arbitration Place to see whether I wished to join them, and I had some wonderful meetings with them, and they had this remarkable team of individuals that I wanted to be with. I don't see them enough because I'm the only person in Ottawa. Bev McLaughlin drops by from time to time, but most of my colleagues are in Toronto. Ian Binney, Doug Cunningham, Warren Winkler, Dennis O'Connor, Bob Sharp. Anyway, the whole group of them. They're a very impressive gang of people, and we're all dedicated to trying to, lessen the burden on litigants, try to narrow issues, try to have a relaxed atmosphere to resolve disputes. And of course, now this is all being done online, as we are doing today. And I just, all my life, in a sense, as a judge, as a lawyer, as a judge, and so forth, I always recognized the profound stress of litigation. And I think that all of us as professionals owe it to ourselves, and particularly to those in whom we're dealing with, to try and lessen the burden of the litigation itself and of the stress level that the litigation brings. So to the extent that we can do that, everything is going to be better, and the resolution of disputes will be enhanced. So it's a question of attitude, bringing an empathetic attitude towards the resolution of disputes that I hope will be the wave of the future.
Well, thank you for saying it that way. Remember, recently Alan O'Brien, one of our colleagues, went to his Lord, and a few years ago, John Nelligan, and we used to have sessions, and John Nelligan wrote the same, what you just said, we don't have to change the rules of court, we just have to change our attitude. Now, you wrote, Your Honor, in 1983, March, the story of the merger of the courts. And just to prove I've done my homework, you had a couple quotes here that are so pertinent, they're so perennial. You said the purpose of this brief, when you were promoting the merger of the county, district, and Supreme Court, the purpose of this brief is to focus on the interests of litigants in particular and the administration of justice generally and its appearance in the eyes of the public. You also wrote that sometimes in the litigation, which I'm experiencing, the purpose is to starve the plaintiff into submission. And you have lots of these big ideas, and you talk about intoxication of anachronisms, and people want, the public should get more bang for their buck. I was at speaking at a conference in Montreal 3 years ago, and the former Chief Justice of Quebec said that the teaching in law school today is no different than the 18th century. It's like, who walks in your office? Your client. You can't give a opinion that's going to be sure to work out. As a mediator, I always tell people, if you change lawyers, you get a different opinion. Do you think, like his comment was that there's not, and I know a lot of people training, and I know the dean, and they're doing their best, but when I stopped my practice, there was not 1 minute in law school negotiation, mediation, anything. Do you think the training in law school, because you've been a professor there and at the bar, do you think it's improved, or how much more does it need to improve in this big telescope thinking?
That's a very good question. I can't answer the question you've just asked. I don't know what specific courses are offered at Ottawa U right now, because I've been away from the law school as a professor for some years. I only go and do guest lectures from time to time. But my recollection is when I was there, I was teaching trial advocacy, ethics, and evidence. I don't recall, Ernie, a specific course on ADR. You know, ADR didn't come really to the fore until 1981, when getting to yes became the, you know, it was similar to Jim Fix's book, The Joy of Running. In other words, it began the explosion of ADR all over the planet. And so the extent to which it is taught at law school, I can't answer that. I don't know. I know that as judges, in our educational seminars, we spend a lot of time on getting to yes. In other words, settlement conferences, how to be an effective settler. There's a lot of attention paid to trying to reduce the amount of litigation, because you know it's incredibly costly. It's as I said earlier, it exacts a terrible psychological cost on those who pursue it. And so any way we can divert litigants from an actual battle by combat in court with a final judgment being given by a judge is a desirable end in itself. I don't know if that's answering your question.
No, it's very good. I co-taught ADR course with Professor Julian Payne in 1991 when I was in Akwesasne as a conflict resolution consultant after the Civil War. And I also co-taught with that famous judge from Toronto who was a lawyer, a judge, and then he became an arbitrator, mediator. He tried to mediate the Nortel dispute.
That's the Nortel dispute?
Yeah. It was a very famous Supreme Court judge in Toronto who became a mediator and arbitrator, and I co-taught with him too. Yeah. But the thing is, if you look at the Law Society recent credits, they have one course called "How to Win at a Mediation." So it's like that's the title of the course, and I've had 2 articling students who said the way they see mediation done by practitioners like me is nothing compared to what they learned in law school. So I don't know is it possible? I've been joking that the legal profession are going to be like gas stations in the future, you know, because everything's changing. Do you think the profession is keeping up with the reality? If you look at the Law Pro magazine 2 years ago, right, Doreen? It talks about challenges to the legal profession, and one of them was ADR. Why is that a challenge? If we use an all-inclusive spectrum, there's something about the philosophy about this. Do you see much hope of the legal profession as a whole on a big level changing its thinking?
Well, I personally think that they're going to have to change their thinking because at the end of the day, it's the client who pays the bills and really gives the instructions. And what I have noticed, this is the same in the medical profession and other professions, accounting and so forth. What I have noticed is that over the years, clients patients are becoming much more
Mhm.
knowledgeable about their position in
Yes.
in relationship to the professions that they are dealing with.
Yeah.
Patients and with doctors are asking more questions. They're more knowledgeable. The internet has driven an amazing amount of knowledge, many of us misplaced, unfortunately, but an amazing amount of knowledge in clients, patients, etc.
Yes.
And they are demanding answers, as a result of which the professions must change and gear up to this new knowledge explosion on the part of clients, patients, etc. So I believe that the profession must change. Clients want the services, they're prepared to pay for them, but they do not want to be taken for a ride. Patients who see doctors want answers to their questions. They want to know, what is exactly wrong with me? What are my options? What are my treatment options? A client with a lawyer should have the same questions. What are my options here? Do I have to go all the way? Do I need surgery? Or can I do this with herbal remedies? Can you help me with that? Can you refer me? In other words, professionals have to understand that they are there to serve the clients, not simply to serve themselves and make themselves rich or give themselves an ego trip by being a professional.
Well, you inspire me to ask you something, if I could, at the telescope level, Doreen, is that by 1988, I had been in touch with the negotiation project with Bill Urey, Getting TS, Frank Sander, the Open Door Courthouse. They were way ahead, way ahead. But every year, the American Bar Association has a centerpiece. And in 1988 in Hawaii, the centerpiece was ADR. And I was the only non-American invited into this room where, and I want you to comment on this, this professor was hired by the government to start with 10,000 federal court cases. So he had this like a staircase. It was 10,000 federal court cases. And then it went down, and then it went down, and went down. And at the end of the day, only 5% of those court cases went to trial. And he asked everyone in the audience, what was happening at that staircase? Nobody knew. He said, that's when the lawyers were forced by the rules of civil procedure to pick up the file. And ADR, if it's best understood, is to voluntarily pick up the file, which is we're pursuing with Gators, the all-inclusive spectrum. Is that still the case today, as from your seeing what's going on, that very few cases go to trial, but the 80% of the high conflict cases take up most of the time, and they're only 20%.
I think that is true. Very few cases go to trial, particularly in the family law and in the civil law. In other words, the number of trials in family law are very few, mainly because the money's all gone after the case conference and after the settlement conference. After those two events, basically you got to settle, otherwise the proceeds from the home will go to the lawyers and not to the litigants. In civil litigation, what happens mostly is we have a very hands-on approach to settlement, as in the family branch. And so there might be 2 or 3 settlement conferences on a civil litigation file before it actually goes to trial. And in the and then we also have mandatory mediation in Ottawa. So that gets rid of a lot of cases. And then when it does get to court, the judges lay on hands and try to settle them. And in most cases, the matter is settled and trials are few. It's very different in criminal litigation. Criminal law, many more cases go to trial than in either the civil or the family branches. And the reason for that is that sometimes people actually are innocent and they want a trial and they want to, Sometimes people are not guilty because the state can't prove it. They may be morally guilty, but not legally guilty. And so those cases go to trial if there's a good lawyer who can defend. And so there's many more trials in the criminal branch than in the family or civil branches.
Well, thanks for that enlightenment. That's important to know that.
Yeah,
it's very important to know that.
There still are. I mean, I was one of the judges who was designated to attempt to settle criminal branch trials. There were a few of us who were laid on, and the leader there was Lynn Ratushny, and her record is just stellar. The amount of settlements that she brokered in criminal law, quite outstanding. Currently, there's Justice Moranger, Justice Phillips, Justice Parfait who are doing that work. So they do have sort of dedicated judges to try and settle these criminal cases, just as we did in civil litigation. Some judges are more adept at getting settlements than other judges. Some judges are better judges. In other words, hear the evidence, write the decision. But there are a group of judges, I like to think of myself as one, who were adept at getting settlements, getting to, yes, win-win.
Right. Very, very good. The you just, again, you're kind of inspiring me to think of people and things, but with David Scott, who passed away, it sounds like a diversion, but one of the great things you did as a judge, and the judges did and lawyers did with REACH, the charity for disabled, we had 4 years of lawyers comedy night, and you were the MC for 3 years.
Yeah, that's
excellent.
Yeah, I forgot.
Remember that was so much fun.
Yeah, there was a lot of fun.
And then, you know, the 4th year, David Scott became the MC. So
why I didn't do it the 4th year, Ernie? Can you remember why?
No, you didn't, because
you fire me? What?
No. You were. It was like I just had to feel, because it was an idea I had. It worked out well. Then I had to feel we should stop it. And you were very busy, and you thought somebody else should do it because it was going to be our last year. And David Scott stepped up to the plate and did a great job. But I have a video on one of those, so we could I could share it with you if I can locate it.
Yeah, well, we'd always start it with a film. I remember.
That's right. You always had a film.
Make a movie and then yeah, okay, those were fun.
It's a good example, you know, Doreen, of how the judiciary interplays with lawyers and the public about you know, community involvement, which is not well known, you know. So that gets to a lot of stuff that he's written here. So it's I think we're halfway through the interview, and there's still a bunch of things that we have to want to cover. So
yes, and I would like to ask this question. And so how do you've touched on it in many ways, but just maybe precisely, how would you encourage the use of more voluntary settlements, especially during this pandemic?
I guess one of the answers to that is people I think are frightened of trials. They don't really want a trial. And I think it's the obligation of every lawyer to inform the client, look, let's try to settle this case. I mean, that was my approach. I think it was the approach of most good lawyers that I know, is they wanted to settle a case. So in the old days, when you couldn't get access to the courts, there weren't these, you know, if you read my article, you see some of the obstacles to just getting to court, and the differences of jurisdiction between the county and district courts and the High Court of Justice, the Supreme Court. It forced lawyers to actually get together and settle on their own in the old days. So you'd phone your colleague and say, could we sit down and have a settlement conference? And you'd go to their office and try to work it out. That's the way it was. And often we did work it out. Now there are many more opportunities that the court has provided in the family law, in the family, civil, and criminal branches, for the opportunity to actually have a judge help you settle. In the old days, back in the 80s, and even into the 90s, you had to do it yourself. You didn't have those aids. So there is the opportunity for settlement. And then if you prefer, there's the opportunity to go out of the court grid. And there's all these experts in ADR, mediation, arbitration, etc. There's many now available, unlike in the past.
Yes.
So the opportunities are vast, in my view, for the settlement of disputes. And I think the expertise of those people doing mediation, arbitration, or in court as settlement judges is second to none. So it's all, the opportunity is all there. To my mind, there's no reason why clients should not insist on those opportunities being pursued with vigor.
In terms of, there's a couple things there before we go to the next topic, because one is going back to what you just said about sitting down. Gordon Henderson, my great mentor, I don't know how I lucked in. He helped me with ADR, reach, music law. Like he just adopted me. Like, I don't know why. And he wrote the foreword to my book in '89. In fact, it was him that got the paper I did to go to the CCLA conference in '88. And that paper became distributed around the world. And I taught at Carleton Law School and it became a book. And it was all because he said, give Ernie some time at the CCLA podium. I was between David Scott and I don't know, somebody else. And, you know, I remember meeting somebody much later. He said, Ernie, that was a great talk. I said, well, what do you remember what I said? He said, nothing. It was your enthusiasm. Greek for God within. But Gordon told me, you know, as I was just starting, it is the next generation of lawyers are doing. He said, we used to do like you just said, we used to just sit down with each other.
Right. Yeah.
Like, what happened to that?
Well, I think, to repeat myself, it was because you couldn't get to court. And there weren't these, they had settlement conferences, but they were just so pro forma, you know. Okay, well, you know, have you made an offer? No, okay, well, get out. It'd be 5 minutes, you know. Whereas now the judges who are assigned to do settlement conferences are fully knowledgeable of the material and are given the time to actually get a settlement. I remember I was given 2 days to do a medical malpractice, and we did it. We got it done. And but in other words, the courts now recognize the importance of giving judges the time to actually do settlements. The old days, the reason we met each other is because you didn't have access to that resource. And so you were forced to, unless you wanted to put your file away and wait for 5 years for trial, put it into storage. If you wanted to actually get a resolution and get paid, then I'd say, Ernie, you want to sit down, see if we can work this out. That's the way it was. And the old tradition was you always went to the office of the more senior lawyer, or if the lawyer had a QC, then
yes,
go to the QC, you know, that was the tradition. And it was, I remember going to see Gary Cooligan, and I sat down, I said, Mr. Cooligan, how are you? You know, and so forth. I'm sitting across from his desk, and I said, Mr. Cooligan, I've looked at this, you know, my client's injuries and so forth, and I think the case is worth $40,000. And he looked at me and said, I agree. Do you want to check now? And I got all nervous saying, oh my God, I'll bet you it's worth 60. Anyway, it was worth 40. He was just a very good lawyer, but you know, it's again, it goes back to the sort of getting to yes. It's not a great idea to start with your final.
Right. The negotiation dance. When Roger Fisher and Bill Urey became a great mentor for me too. He was the advisor to President Carter at the Camp David Accords, but they said that a dispute between two spouses is no different than the dispute between two nations. Like, wow, that's like, that was
actually, some are worse.
well, I can mention Ian Scott again. You had lunch with him. When I was in Toronto at this 3-day conference, he invited me to lunch and he told me something I'll never forget. And I want to get your comment on it. You might have heard it from him before. He said, Ernie, we got to understand, we need courts for constitutional disputes between provinces and the federal government. We need the courts because of criminal law. We need the courts with high conflict cases, but most of the disputes between people should not be going to court. And he was pushing for what we're talking about here, but he really put it in a way that there was a balance about understanding why we need the court system, and we do have to need the court system. But he kept saying, you're working with the general public, grassroots. Why do so many of these cases have to go to court?
Yeah, well, let's talk about going to court. I think what Ian might have meant when he was speaking to you was going to trial, not going to court.
Mm-hmm, mm-hmm.
We need, and we have gone to made great efforts at ensuring access to justice. When I spent that year of my life we're pushing for the merger of the county district courts with the Supreme Court of Ontario, I went all around the province speaking to all law associations and so forth. I had debates with the various Toronto lawyers who were opposed to this idea. What that whole thing was about, the idea of merging the courts and then decentralizing them and having regional courts, which Ian Scott finally got done in 1989. The whole idea was to enhance access to justice. The old system didn't work. I won't repeat what I wrote in the article in the Gazette that will be available to those listening.
Yeah, and it's on the Gators website.
They can read it. But the point of the whole idea was to make litigants, give them the ability to get to court,
Mm-hmm.
to actually get to a judge. And because previously, I mean, you'd have these, as I call them, Roman centurions coming down from Toronto, generally in a bad mood. In winter, they'd not get there till noon because of weather, and you had jury panels waiting. And then on Friday, they wanted to get back to Toronto, and so they were giving you all hell to wrap up your case, etc. It just didn't work. It was not good. Justice was not accessible because of the form in which it was tethered. And when all that changed with the decentralization of the courts and the merger of the High Court and the County Court, you saw the difference immediately, the access. And now we have mini circuits within the East Region, for example.
Mm-hmm.
When I was sitting, I'd go to Brockville, I'd go to Belleville, Cornwall. In other words, we'd circuit around. And it was terrific because you brought a fresh sense to that town, and we're able to get tremendous amount of settlements done. And it was local, and people knew they could access that court locally. They didn't have to wait for a Supreme Court judge to come from Toronto to deal with their issues. Plus, what has grown up, as I averted to earlier, is the whole philosophy of the court to attempt to get settlements and relieve litigants of the stress and cost of trials. And so in every area, in every region in our province, there are dedicated judges who are proficient at obtaining those settlements.
And as you've mentioned, as a practitioner 45 years, lawyers always talk about who's going to be the judge at the case conference, settlement conference, trial, because that judge's reputation is really critical in terms of being, as you said, being able to get people to think through. Sometimes you have a client who's so stubborn, they need a judge to say something. But I want to ask you another question at this level before we move on, Doreen. A few years ago, I was at an international conference in Montreal again called the Children First Movement. There were dozens of nations represented. And I was sitting with someone from Australia, and I couldn't believe how backwards we were here in Canada and Ontario, because in Australia, they spent hundreds of millions of dollars setting up a triage system equal to a hospital. So when you go to a hospital, you don't see a doctor. They put you through a triage. They take your blood pressure. They take your, they take x-rays. They do this, they do that. So in Australia, unless it's changed, lawyers are not allowed, except in an emergency, to issue a divorce petition. They got to go to a social worker. And the government has psychologists, social workers, co-parenting counselors, and mediators available. In the long run, everyone's better off. It's a triage system. I thought, where we are here is like we're like in the dark ages compared to other jurisdictions. And I can name many, many others who are so far ahead. Why is that?
Well, I'm going to take issue with you. I think that the current family law branch is doing a wonderful job, and it's peopled by marvelously talented individuals, and so there's certain mandatory aspects to it. There's a mandatory parenting section where the parties must go off and learn the risks of litigation. All that is taught to them, and then there's this the case conferences, where the judges are very hands-on, try to narrow the issues and try to actually have a settlement conference during the case conference. And then there's the settlement conferences, and 99% of those cases are settled. So I look at the colleagues I had in that branch, and I did that work also. We all have to do it. But the ones who are the specialists are, I think, superb at getting settlements and recognizing the stress and the concern that litigants have. So I mean, of course, there's room for improvement. All you need is bucketfuls of money. And you can have psychologists and social workers and all that as an adjunct to the process of dealing with people's disputes in the family law. But what we do have now, I would argue, are highly, highly dedicated, trained individuals who are in the family branch and resolving disputes to most people's satisfaction. Plus, you have a very, very engaged family law bar of specialists,
yes,
who understand the dynamics and who bring about those settlements. You can't have a settlement without counsel buying in. We can also talk, if you wish, about self-reps. That's a whole different subject that I'd be happy to talk about, because I did a lot of trials of self-reps.
Yeah, I'd like to maybe have another session with you about that, because Doreen, listening to that professor, the woman professor that did a whole book on self-reps, and she was going to be an interviewee from Windsor.
Julie McKinnon, Professor.
Yeah.
Not Julie McKinnon, Julie
McFarland. She did a great job on on Muslim stuff and self-reps, and I'd love to do a session with you on self-reps. But I
you know, look, I I did the Tarankari murder trial. It took months, and he was self-represented, first-degree murder. And then I did the G7 cases. There were about. It started with about 15 accused. They were all anarchists.
No.
Yeah, and that was a jury trial and self-represented. And I got the call to be the judge on that, and we worked it out. Like, I'd love to talk about that case.
Well, I'd love to. I'd love to talk about other cases too, because judges with self-reps, like I've heard from judges. I mean, this is a side thing, but I wanted to mention something else. I don't want to forget, but some judges were telling me that there's a self-rep, and then there's a person represented by a lawyer, and the judge is trying to get the self-rep to do it right, and the self-rep complains to the attorney general that the judge is taking their side. The side of the other person with the lawyer. So like, how do you balance it out?
A delicate process, because the litigant who has a paid lawyer there does not want to feel that they're getting the short stick because the judge is bending over backwards to favor the self-rep. So being a judge when you have two parties, one of whom's represented and one who's not represented, is a very, very difficult task, and needs.
Yeah.
You need a lot of experience to do that. I think that at the end of the day, I, for whatever reason, was assigned a lot of self-rep cases, but I believe that a judge gets what he gives, or she gives. In other words, I was taught. I did a murder trial with Peter Corey. And the tone he set in that courtroom, he was a high court judge then, when a lot of them were real SOBs and treated everyone like crap. He treated everyone like gold, and he was calm, and he was collected, and he smiled, and he was friendly. And I said, you know what, if I'm ever a judge, that's the kind of judge I want to be. And so you got to set a tone for the litigants where they feel comfortable, they feel they're being listened to, they feel that, yeah, okay, this guy gets it. But at the same time, you can't be a pushover. You have to be assertive on certain issues, and you got to tell the litigant like it is, and what might be expected if this thing is going to go to trial, or if it is a trial, what the rules are for the procedure. And you lay those down, and they have to be followed. And the judge has to lay down the hand that the judge has warned will be laid down when the time arises, so that fairness throughout is the rule of the game. So you get what you give. You give respect, and in turn, respect is given back to the judge.
Well, I would love to have another future discussion about the ethics of plea bargaining, which has been challenged by many academics. But you made me think a couple more things before we try to finish off here. In Washington years ago, Ottawa was invited because we started Canada's first high school peer mediation program, for which there is a book. We did a great, wonderful event at the Canadian Government Conference Center. So a bunch of us went, and Edward de Bono, the great educator, said something to 1,000 people or more on education. He said, the mistake is when a new idea comes up, you know, an invasion in our armies can be defeated, but not a new idea whose time has come. It's in my book. But he said, don't get rid of your court system, improve it, but build something parallel to it. It was such good advice that opened up my mind to the all-inclusive ADR spectrum. So I want to ask you about that. And then the one thing you just said that I've been wanting to ask you about is, I've been feeling, which I've talked to the Law Society about, Law Pro, the Law Society of Ontario Code of Conduct and most codes of conduct that are federally reconciled says lawyers must be vigorous advocates, but they also must look for early settlement. It's almost schizophrenia. And I meet combat litigants who don't do anything. I was going to report one combat litigant, but the law society said, look, you know, Ernie, for what you're doing, is that going to help you? How do you reconcile? First, I want to ask you what Edward de Bono said, and how do you reconcile those two obligations?
Well, they're obviously conflicting ideas, but it doesn't mean they're irreconcilable. A lawyer has a duty to represent their client vigorously and within the boundaries of ethics. The lawyer also has a duty to try and resolve that client's dispute. I do not see that as schizophrenic nor an irreconcilable situation. It happens every day. What is required? What is required is a well-educated bar, lawyers who understand both those obligations, a mediator or arbitrator or judge who understands those obligations and is ready to put the work into getting the settlement done. It's all, you know, it's the old story. Preparation is everything. 99% of it, you know, you're not going to get a settlement if the judge walks in and has not read the material. It's not going to happen. What has to happen is the judge is completely familiar with the material, walks in, and immediately, or within a few minutes, demonstrates to the parties that he has read the material or she's read the material.
Yes.
That's important. And then once the parties recognize, hey, this judge has got it, then they're prepared to listen to that person and be guided by that person. So the judge must be prepared, the clients must be prepared, the lawyers must be prepared, and everyone has to go in there understanding that they have a role. My role is to represent this person and try to get the best deal I can for my client. But at the same time, I have an obligation to get a deal. So that's not irreconcilable, Ernie. That's the process. And the judge's job is to try and balance the two sides. Sometimes one side is the winning side, and the judge has to convey that. It might be privately in a sidebar, but you know, everyone has, it's a group process. Not one individual. The judge, because you have one good judge, it doesn't mean that judge is going to get everything settled. Everyone has to buy into it. Everyone has to be prepared to say, okay, this is a settlement conference. The purpose of it is to try to achieve a settlement, not to go there and undermine it. And some lawyers do that. Now, what do you do when that happens? Well, what I do, if I've been dealing with a lawyer who is completely unreasonable and I realize he's just, or she is just trying to jettison the process, undermine it, I'd say, I'd like to speak to this lawyer alone. And I will say to that lawyer, listen, I think you're playing games here. I think you're wasting time. You're wasting your client's money, and you're wasting valuable court time. Court time is just like hospital time, like an operating theater, all right? You only get so much time. A lot of people are lined up waiting to get their new hip, waiting to get their heart fixed. And if you're just coming here to joke around, then you know what? I am going to be very, very direct about you with your client. And I don't think you'd want that. I don't think you'd want me to say that. So why don't you go out and start getting serious? So that's in the where you have the really tough, hard ass lawyers. That's how I dealt with them.
Well, it's very humbling.
Yes.
When a infamous retired Superior Court justice takes issue with the interviewer, and I have been listening very, very carefully, and I've learned quite a bit. I know we don't have much time left, but your papers, like I really hope that people read the March 83 Gazette, which is in our site on the merger and your CCLA history. But in addition to talking about the merger of the courts where the solicitors were now neighbors because of the registry office.
Yeah.
Came in at the end. It's that when I ask lawyers now, do you know what 4 roles lawyers play? I could tell you 9 out of 10 don't have an answer. We're barristers and solicitors, which ironically is BS, right? It's just turned out that way. But we're also mediators and arbitrators. Mediator is referred to in the Law Society, but not arbitrator. But Law Pro said arbitrator is covered by the lawyer's insurance. So it's really important to expand our role. But I want to read the last paragraph. If I can end with this from your paper on the history of the CCLA. It's a beautiful ending paragraph. You write, to be in the company of the individuals mentioned in this paper is a great honor. To be able to serve all those not mentioned in this paper and perhaps should be mentioned is no less an honor. To be a lawyer, however, and to have a good luck to be a small part of the development of our noble profession is, to my mind, a privilege that ruffles the skirts of duties. That is so beautiful. That was September 1988. When you reflect back on that sentiment, and now where you are with arbitration place, a retired judge, and how do you feel the same way?
Oh, absolutely. I can't tell you how much I loved being a judge every single day, walking in a court and being able to try and make a difference. Just do my little part. I used to have this prayer every single time I went into court, every single time. Might be 5, 6, 7 times during a day if it was a case conference, if you were doing case conferences, settlement conferences, etc. I'd always stop at the door and silently say, thank you, God, for the privilege of being a judge. And may I remember that I too am being judged.
Amen. That's very beautiful.
It just grounded me, because we all hated those judges that had judgeitis. I go back to my hero, Peter Corey.
Yeah.
Who just treated everyone like gold, and yet could be firm when he had to be. But that's the person I tried to emulate. I don't think I did it as well as he, but I sure tried. And there's just no greater joy than ending a day where you've gotten a number of settlements. I remember I went to Toronto to help them with their long trial list. And I spent 2 weeks there doing just settlement conferences on long trials. And I got every one settled. Every one. And it saved, well, it would have been like something like 8 years of trial. So yeah, I remember going home, coming home from Toronto and just feeling so satisfied, so good.
Wonderful to hear.
You don't
often hear that. And, next time we talk, or one of the many next times we talk, I hope, is that there was a litigation matter where I was the trial lawyer for the plaintiff. And you came in and boy, you had read everything from beginning to end. I thought, oh my God, he's already made up his mind. But then we went to the Court of Appeal who upheld you. But it was a precedent-setting case in the Commonwealth world about Islamic arbitration.
That was Marui and Marui.
That's right. You got it.
Indeed. Yeah.
And then there was another day, I spent all day in the court hall doing a mediation with a Muslim couple with the lawyers, and walked into your court at the end of the day. And I will never forget how wonderful you were. You thanked the parties for settling on the custody dispute. You said, judges don't want to make decisions on who gets custody and access. Then you thanked the lawyers, and then you thanked the mediator, which is me. And it was beautiful to get that kind of feedback from the bench but I knew you were the judge, and they worked all hard that day because they wanted to come in because they knew you would commend them. And that's a very important thing.
Yeah. Thanks, Ernie. That's a nice memory.
Yeah. So Doreen, we're going to have to close off. Maybe, hopefully, Justice McKinnon, you'll join us again.
Well, I think we should do this again. We haven't covered half the stuff we were going to.
Exactly.
Exactly. We look
I
forward
definitely look forward to it. This is so beautiful and wonderful. As a member of the public who has been involved with Ernie for over 10 years, I'm really grateful to have you here today and to engage in this conversation with both you and Ernie. It's so informative also to hear about the bench and some things, I've never experienced it, thank goodness. So you see it on TV, in movies, but this is real. This is real.
It's called humanizing the knowledge. And I think, Justice Chadwick, yourself, are you going to humanize the knowledge for the public and even the profession to see judges as people?
Yes.
Well, I can tell you, our RSJ Chadwick was particularly good to me. I can tell you, he really fostered me and gave me great.
Oh, nice. That's nice.
Great cases. I always remember he gave me the Morgan murder trial, which lasted that year. I only took 2 weeks of holidays because that trial took 9 months, 3 months of pretrial motions and 6 months of trial. And anyway, just a wonderful, wonderful exercise. And we went out to lunch after, and I said, "Gee, Jim, can I get another of those wonderful homicides?" He says, "Colin, we're going to lower your profile."
Unbelievable.
I think he put me in motions. Used to be motions week for about a month. So, oh boy.
Wow. That litigation.
He was exceptional.
Motions.
He was an exceptionally gifted. Well, in every way.
Well, Justice Chadwick and Justice Bob Baudouin, judicially, I think you were involved in getting the court annex mediation mandatory in Ottawa. When I went to the downtown hotel where they were being honored, and Justice Chadwick was so good, he said, "Ernie, the bench was not unaware of what you've done, but they took the lead. They had the Bob and Jim show. Do you remember? They traveled across Canada. Across Canada.
No, Justice Baudouin is just an exceptionally gifted man. The Bob and the Jim and Bob show. They went all over the world.
Telling people all over the world, do this, do that. We should be very proud of our jurisdiction, and we are so proud at Gators, and I'm proud personally that you're taking your time and working with us to get the word out, and that you're going to continue to be with us in the future.
Can I just tell one story, please?
Yes.
Have you got time?
Yes.
Yeah, right. I remember when Justice Chadwick initiated this this plan to get rid of the backlog. There was this huge backlog of civil cases. You're taking 5 years, as I said earlier, to get to trial. So he approached senior members of the bar to become settlement judges. I was one of them. And I was assigned, I think, 10 cases and I'd work like hell. And this was for free, okay? Worked like crazy. And I'd have people into my boardroom, and if you got a settlement, then it was sent to the court and had to be signed off by a judge of the court. We killed the backlog. And then finally, we get assignment court. I go there. It's the Monday, and I had this case that was outstanding. It had to do with the shares in Japan and it was a complicated commercial case. And anyway, so there I am, proudly standing before Chadwick, having settled my 10 cases for him, etc. And I said, well, he says, so he's going through the list, and this case comes up, Metcalf Realty against my client, McKim. And I said, Your Honor, yeah, I think I could be ready in 2 weeks. He said, you're on Wednesday morning, 10 a.m. So, God, we have to get the file out of storage. I had to, the junior lawyer I had, she was a new mom on leave. We had to get a caretaker for her baby so she could come in and tell me all about the case. And we went to trial on the Wednesday. We finished it on the Friday. Friday afternoon, we made submissions on costs, and it was all done with. That was Chadwick. He was the judge on it, and I won my costs, I'm happy to say. Yeah.
It's wonderful.
Oh boy, he showed no mercy, that man.
That was wonderful. Yes.
Hard
And
to-
I have, before we go, I have a quick question for both of you, actually, for especially for Justice McKinnon. In today's chaotic situation with, you know, physical distancing, how are you dealing with this, and how is your wife, how is your family dealing with this?
Well, it's very difficult for me because I can't see my grandkids and my kids. So it's been very, very hard, and I don't like particularly the Zoom stuff. I mean, the kids come and go. They're not interested in sort of sitting down and Zooming. It's not the same as being together as a family unit. It's very hard. But I look at myself as being lucky because I think of the young people, young moms, young dads. I think of my kids who have their children at home having to learn and then doing their own jobs. I mean, the stress and it's really a tough time for them. So mental health is really important. I think exercise is really important. I try to get out every single day and walk at least 1 hour. Sadly, they closed. Yesterday was to be my first golf day, and they closed down the golf courses, which didn't make me happy. But no, I think, listen, I'm reading a book now called The Splendid and the Vile. By Eric Larson, and it speaks of 1 year in the life of Sir Winston Churchill when the Blitz was undertaken. And every single night, hundreds of German bombers would come and bomb London or other cities, and bombing factories that made food. Okay? And this, you know, I think, God, you know, here we are going through the pandemic. It's tough, but nothing like happened to the generations before us. My parents lived through the First World War, the Great Depression, the Second World War, then the Cold War. We've been extremely lucky, our generation. So we've just got to count our blessings. Everyone has challenges in life. The pandemic is a challenge, but we'll get through it. You need a couple of things to do it. You need to get your mental health in order, and that means, you know, reading, thinking, discussing with friends, etc. Watching maybe some really good series on TV, but and then your physical health in order. You got to get exercise. You got to get out. You got to get air. You got to walk around. Just a little piece of advice. What we've done, my wife and I, we choose different parts of the city to walk in, and then just walk the neighborhood. You go to Rockcliffe, you go to Westboro, you go to the Rideau Falls. There's so many areas to walk in that are really different and wonderful. Go to Mare Bleu and walk there. Previously, the Gatineau Park, etc. So you got to, you know, don't just stick to your own little neighborhood. You can circulate and park and then walk and just learn about our city. I know more about our city now than I ever thought I would. So you look on the bright side. We'll get over it.
Yeah, so it could always be worse. That's good. You got the last word. It was well said. And I get up every morning and thank you, God, for another day, and things can always be worse. So yeah. I think you said that very well. And I'd like that to be the way we segue to the next session.
Yes, exactly. And on closing, I would like to say thank you very much, both of you, for being here. Justice McKinnon, it's been a pleasure.